Thanks, Johnny. So hopefully, Johnny has convinced you of the importance of giving us complete data and all the benefits of giving through as much data as you can and complete, accurate data, and advising us if there's any changes to that data. So he's given you the carrot, and now I'm going to give you the stick with regard to why we need all of this data. So there is actually a law that says we need all of this data. And it is a fairly recent piece of law, so that's why we thought we'd chat to everyone about it today. So it's actually linked to contributions that are paid to the fund. So the data is very important with respect to the contributions. But what was the background to this document that was issued by the Financial Sector Conduct Authority was that they experience and they get complaints, and many of us in this room will know or had complaints from members where contributions are not paid on time or at all by employers to retirement funds. And there could be various reasons for that. I mean, there could be, significant financial hardship by the employer. We specifically experienced that during COVID, where some of the employers were suffering from financial difficulty and couldn't pay the contributions in time or the complete amount of contributions in time. But that is kind of understandable, and there are solutions we can put in place to try and deal with that particular problem. What is really problematic, and in fact is criminal, is where employers deduct the contributions from the employee's salaries and don't pay them over. So you, the employee, think, you can see it coming off your payslip, you assume it's going to the retirement fund, and we're sitting here and we didn't receive it. So that is actually a criminal offence. And those were some of the challenges that the FSCA were experiencing. There's also, life has moved on, and they were getting reports of, non-payment of contributions or late payment of contributions. They have to report it through to the FSCA. They were getting reports in different kinds of formats, reports and information that was given to employers about their obligation was in different formats. So that was one of the other challenges they experienced, was that not everyone was giving the same kind of message and the same kind of information to all of the stakeholders. So what they've decided to do is the Financial Sector Conduct Authority, and they regulate us as administrators as well as all of the funds, they've issued this conduct standard. And as I mentioned earlier, a conduct standard is law, so we don't have the option as to whether we like to comply with it or not. And it actually, there's sections in the Pension Funds Act which deal with contributions, and then this conduct standard just gives more explanation as to what is required and what information is required. So they actually finalised it. It's been quite a long time in the making, this conduct standard. It was issued last year. We did issue communication out to all funds and employers about this conduct standard. It had a 6-month transition period. So it only came into effect, well, we say that it was actually the 19th, but the 19th was a Sunday. So it's actually the 20th. So it has been effective since the 20th of February. But certainly from what you've heard, from Johnny and the admin team, I mean, we've been communicating for quite a while in terms of the information we need monthly from employers. So the fact that this has now been finalised should have come as no surprise. So one of the first things that this conduct standard says is that, and this is more typical in an umbrella fund, we have new employees joining all the time. It's not necessarily the case in a standalone fund, but in the case of an umbrella fund, every time a new employer joins, and for every existing employer once a year, we need to remind them of what their obligations are, to pay the correct contributions in time on the fund, and to submit the contribution schedules to the fund in time. So they've got two obligations. One is to pay the correct contributions in time, and one is to submit the correct contribution schedules on time. And that's why the two are linked together in this conduct standard. So the data is important, but also the money's important as well. So what they've done is they've attached to this conduct standard a template letter that needs to be sent to the employer. So every employer will get exactly the same message, no matter what fund they belong to. They will get exactly the same message saying these are their obligations. One of the other issues which gave rise to the conduct standard dealing with this is interest. What interest is payable on a late contribution? And it was always quite difficult to kind of figure out when we start calculating and what the rate was. I have to say it's still slightly confusing. So when we raise this with the FSCA, they're going to actually issue a guidance note explaining how this still works. But our understanding from what they have said is that the rate is easier now. It's basically the prime rate plus 2. So we know what it is. We know it's compounded. And we know that it is calculated from the first of the month. Do you know contributions have to be payable by the 7th of the month? If the contributions are not paid by the 7th of the month, then the interest starts running from the 1st of that month until it's paid. So those are the 3 things that we know. But as soon as we get the guidance note, obviously we'll communicate any changes that we need to in terms of our communication or our processes. So that was the other important thing about the interest that is payable on any late or non-payment of contributions. Then moving on to these contribution statements. So there is a long list of information that is needed. And they talk about the first contribution statement. And this is obviously looking at a situation where this is the employer's first contribution statement to this fund. And the first type of this slide shows you, and I'm not obviously going to read it because you're probably all reading it over my shoulders now, is that it's information, generic kind of information about the fund and the employer. And that should be information that doesn't really change unless the employer changes its name. The 2 points that I want to focus on today, and this is really important for anybody who's in the HR department or the payroll department, is number 6 and 7. So number 6 is the contact person at the employer. That's the person typically in your payroll department or your HR department who is responsible for interacting with Alexforbes and the fund on a monthly basis to make sure the contributions are submitted, correct contributions on time, the contribution schedules are submitted on time. This is the person, the go-to person, the person who's probably doing all the work. The second one, the 7, is the person at the employer who's personally liable. This is the person who will go to jail. Do not confuse the 2 up. Do not put your name under number 7 if you are not the one who's going to go to jail. So that will typically be your FD, your CFO type of person, your person who's responsible at your company for the financial running of the company, or a director. If you don't put a name of somebody, for example, your FD, it'll be all the directors. They'll all go to jail. So your call as to your career limiting move, whether you want to put them all down or just one particular person that you would like to go to jail. But hopefully none of them go to jail. So this is what the law says. The law says is that this person, so it's either the named individual, the FD, or the whole board of directors, is the person who's personally liable to make sure the contributions are paid. If the contributions are not paid, and I'll talk now about the reporting, but it gets reported to the police, there's a civil claim, there's a criminal case. Note 2 things. It can be a criminal matter, so it is a criminal offence not to pay, hence I say going to jail. And the second is that it can also be a civil claim. So the fund could have a civil claim against the employer, that individual, and actually go and then attach a car, a house, a computer at the director's place of residence. So this is really serious and it's really important. So it's important that we know who this person is from on the contribution schedules, and that you don't get the 2 mixed up. Then this is the list that carries on. Now this slide shows you all of the information that we need about the members themselves. And as you can see, it is an extensive list of information that we need about the individual members. And there's a reason why the FSCA have said we need this information. They can see the complaints, they can see how funds can't get hold of members to notify them of something because the employer says, give the information to me, I'll distribute it to the members. When we have transfers, we need to pay out claims. the income tax number is often a challenge if we don't have that on file. And as Johnny said, I mean, if this information on the schedule aligns with what we see in the claim form, it will definitely expedite the payment of that claim. Email address, and that's the personal email address that Johnny was alluding to. Then contact numbers, so we can send SMSs to people. So all of this information has to be provided to the fund on a monthly basis. The amount of the contributions and the details of any additional voluntary contributions. And I guess this will be more important going forward, potentially, if we need to know how to split the contributions. But this is, I say, quite an extensive list of information that we need. But the good news is that once you've done it once, then going forward, you only need to then notify us of any changes to that information. So you don't need to, keep sending us or just notify us of the changes. So, for example, obviously, if somebody's joined service or left service or gone on maternity leave or whatever the case is, gone on disability, any changes, for example, a promotion and they receiving more money or annual salary increases, that type of thing. So then the membership number of the fund, that's something that we give you, not the employer. So obviously you only get that once somebody's actually joined the fund. The important thing here is also this declaration at the end of the contribution schedule. And there's a reason why that is there. Unfortunately, a lot of this conduct standard, there's like cases behind it and like terrible situations which have happened. And so now you can see why they put it in to fix some kind of harm or prejudice that has happened. So what has happened in this particular, what we've had is we've had individuals come to us and say, I've left service, can I be paid my money? And we say, we don't have a record of you. We didn't receive a single contribution for you. We don't have you as a member of our fund. So we have nothing to pay you. And these are people who were eligible employees and the employer never put them on the fund. And we only realize obviously when the person leaves. So this particular declaration is obviously to try and make sure that the employers think twice about, is this list the complete list? Are all new joiners, new employees who are eligible for membership of the fund actually on this list? Because down the line, if there is a similar case and the employer and the employer saying, oh, I did put the person or I didn't put the person, we've got the declaration and the contribution schedules. Kind of from a legal point of view, it makes my case a lot easier when I can say, well, look here, you signed and you didn't put the person. So then what the employer will have to do is pay in all of the contributions plus interest so the fund can pay it out. So that is the reason for that declaration, to make adjudicator cases a little bit easier because they've specifically found this type of problem, typically on industry funds. So then I'm moving on now to the reporting. So I think the FSCA, another problem they've encountered is that often trustees kind of are a bit relaxed about taking any action against an employer. And there could be reasons for that. I mean, if your FD is on the board of trustees, then, he may not be very vigilant about lodging a complaint against himself if he's somehow involved. Or people don't want to, get into trouble with their employer by raising any issues about late or non-payment of contributions. So the FSCA's experience is that sometimes the trustees are not as proactive as they should be in dealing with situations of late payment or non-payment of contributions. So what they've said here is that where there is a contravention, either in the payment of contributions or the schedule, so both of them are by law have to be done. This is where the stick comes in. So, Johnny's asked you nicely to do it. So he has all the data and he can pay the claim. And I'm telling you, you have to do it. Because the law says you have to do it. So if the contributions are not paid, or the schedules are not submitted on time and correctly, then the fund has 30 days to communicate to each affected member. That's why we need their contact details. So we can send an SMS or an email to them directly and say, by the way, your employer paid your contributions late. Quite interesting for you as an employee if you're sitting there and you could see that, oh, my contributions got deducted from my salary on like the 25th of the month, but like 3 weeks later they still weren't paid to the fund. You're soon going to have problems with your staff if that is the case, if they're not paid on time. Sometimes it can be just a pay point that is problematic, so the contributions are not received in respect of a specific pay point. If we can identify that it's just a pay point, and so we will, then the fund needs to notify all the employees linked to that pay point. If we cannot identify which group of employees the late contributions or the schedules relate to, we're just going to notify every employee. The fund will notify every employee of this contravention of the Pension Funds Act, and also notify the FSCA. So that's the first level of reporting. So it's to the members and to the FSCA. If the contravention carries on, so the first one was 30 days, if 90 days later it's still not fixed up, contributions plus the penalty interest haven't been paid, the contribution schedules haven't been submitted, the fund then again needs to contribute to all of the members again, but also to the police this time. And one of the template documents on the conduct standard is a document that we can complete it to be given to the police. There are still some challenges in kind of educating the police. They're not familiar with the Pension Funds Act. So sometimes, you know, if the monitoring person or the PO goes to the police and says, I want to lodge a case, a contravention of Section 13A, they look at you like, what are you talking about? So there is an ongoing, the FSCA are trying to engage with SAPS and the National Prosecuting Authority. Because remember, the police just investigate it, but it's up to the National Prosecuting Authority to actually institute the criminal case against the individual director. So that's on the criminal route. One of the challenges is that that the FSCA say that trustees are not proactive enough, is that the trustees will say, oh, well, I told the FSCA, and then they do nothing about it. It's the trustees' duty to do something about it. It is not the FSCA's duty to do something about it. So one of the things is obviously the reporting that the trustees have to do to the member, to the FSCA, after 90 days to the police. But there are also options, and once the criminal case you report to the police, admittedly it's more difficult to influence that process and that route because it is up to the police and to the National Prosecuting Authority. You can make inquiries, but you can't actually proactively do anything. The other route that's open to funds is to actually go to have a civil claim. So you issue a summons against the employer and say, you owe us, you know, X amount of arrears contributions plus penalty interest plus the LPI until it's paid. And that's where I was talking about. Then if you can get a judgment and a warrant of execution, then you can go and try and claim goods from the employer or the individuals, if you name them in the summons. So there is that route also. There's another route open to employers. Or to funds, and that's to lodge a complaint against the adjudicator. There you don't even need to appoint a lawyer. You just lodge a complaint, and the adjudicator gets lots and lots and lots of complaints about non-payment or late payment of contributions. So that's another route that funds can take. They can lodge a complaint against the employer at the adjudicator's office, and then if the adjudicator issues a determination against the employer, that has the same effect as a civil judgment. So you can then take that civil judgment, get it made into a warrant, give it to the sheriff, and before you know it, the sheriff will be off getting you know, goods, computers, coffee machines from the employer to satisfy that debt that is owing to the fund. So this is where the FSCA is being, you know, saying to trustees, you actually need to do something about this. And you can't rely on the FSCA to take action against the employers, as the trustees are the fiduciaries and responsible for the members and must act in the members' best interest. But I did say at the beginning that not every situation where the employer hasn't paid the contributions, the full contributions in time, is necessarily because of something, you know, manipulative or underhanded or criminal. There are situations, and as I said, particularly in COVID, And we had this also, as I said, I'm a trustee on the FR, so we experienced this with COVID, and then again with the KZN unrest and the KZN floods, that some of our clients, like their factories were burnt down, so they couldn't pay, or their factories were washed away. So there are legitimate situations of hardship. And what we are appealing as a trustee, wearing my trustee hat, is for the employers to come to the fund sooner rather than later and say, look, we've got a problem. And then we can amend the rules to reduce the contributions. And we did that for employers during COVID. We reduced, we have to do a rule amendment, and we have to do it prospectively, and we have to communicate to the members that this is happening. Again, unfortunately, to make sure that the members are aware, make sure the right amount, if anything, is coming off their salaries. But we can reduce the contributions to just make sure, for example, that risk benefits are paid, because you don't want somebody passing away and then you don't have an insurance benefit in place. So that can be done. And then if some members do want to pay in more, then they can pay AVCs into the fund. So there are mechanisms that we can use to help employers who are in financial difficulty. Then the other thing that the FSCA wants to do is, if going to jail or going to the adjudicator or going to courts wasn't enough, the other thing they're talking about doing is naming and shaming employers on their website. They've been talking about this for about 6 months, and quite interestingly, and this is their words, not mine, they are worried about being sued by employers if they put them on to their website and say, XYZ Pty Limited has not paid their contributions when in fact they had. And you're kind of defaming them and putting, it's a reputational issue if you put it on the website. So they are like triple checking the data to make sure that these employers are in fact in arrears. And somebody else, I was at a conference or something, and somebody said, well, what's the point in putting on your website? And I believe the FSCA, you'd be surprised how quickly the word would spread. Your members aren't typically looking at the FSCA website, but if it's picked up on social media or whatever, it won't take long before your members realize what has happened. It wouldn't be something as an employer I'd like to test to see if it is picked up or not. So that is something that they are looking to do as well. To try and look after the members. So this one I've already touched on is that, it's not only the employers that have obligations, but the trustees have obligations as well. And the trustees' obligation is to make sure that the employer meets their obligations. And trustees must follow the requirements of this conduct standard as well. I'm not sure if those of you are aware, but there is what they call almost like a tolerance level of 2.5%. So if contributions are short by less than 2.5%, we don't have to do all of that reporting. And I guess it's just a matter of materiality, that 2.5%, could be due to changes in staff or a sale of a division or something like that. So they don't consider that less than 2.5% material. So you don't need to go through all that reporting, tell the members, tell the FSCA, report them to police. However, there are pains to say that doesn't mean you can ignore it. So the trustees can't go every month, it was less than 2.5, we're not too worried about it. You actually do need to investigate and engage with the employer and say, why was it less than 2.5%? So we do still have to do something about it. Then I've also touched on the adjudicator and the complaints there. So the one new thing that they've started at the adjudicator complaint is no matter what somebody goes to the adjudicator to complain about, they now have a question on the complaint form that says, do you want us to find out about your contributions to the fund? And it's kind of a tick box. So the person can say, yeah, well, why are you finding out about my death benefit or my disability benefit or the death, the 37C or whatever else it could be, investment return. Could you also check that all my contributions have been paid to the fund? So they've added that as a standard. So we need to be aware that the complaint could be something entirely different. And then suddenly we have to respond to the adjudicator about the contributions as well, which is fine. And as you can see, 51% of complaints to the adjudicator relate to the payment of withdrawal benefits. And it could go back to your question about, maybe a delay in the payment because we're doing more checks, or their tax affairs are not in order, or whatever the case may be. And so people will lodge a complaint about the delay in the payment of their benefit. And then you find out, actually, we haven't received all the contributions as well. So then they've got two complaints about the quantum and the delay in the payment. I've spoken about funds going to the adjudicator. It's free, and it is much quicker than going to court. And then I've spoken about the tick box. And that is it for the contribution statement. So hopefully I've scared everyone completely, and you'll rush off now. And we should do this the other way around, Johnny. Are there any questions, Geraldine?
Yes, just one. I think you've touched on the majority of it. So how do we respond if the employer deducts the funds and does not pay over? I came from an employer who deducted and did not pay over from April 2020, and nothing was done to them by the authorities.
Yeah, so I think, and that's going to the point that I mentioned earlier about many trustees do not take action. Sorry, that was very unhelpful. I wasn't talking into the mic. So yeah, in this particular case, the employer had deducted contributions, not paid them over, and nothing had happened. And it is a challenge. The first challenge is it's not the FSCA's job to fix that problem. It's not, it's the trustees' primary duty. But also there is the challenge of the police. So I'm not sure which authorities they're referring to. But that's why I've pointed out all of the other options available to trustees. So you can't say, well, the FSCA did nothing or the police did nothing. Well, you can go to the adjudicator. Nothing stops the trustees from going to the adjudicator if that is a problem. You can't just shrug your shoulders and blame somebody else. One of the other legislative changes that's coming down the line is I'm not sure who's heard of the COFI bill, the Conduct of Financial Institutions bill. So this is a new piece of legislation that's coming down the line, and they've introduced a definition of supervised entities. And these are entities that the FSCA will have control over for certain purposes. And it is specifically intended for employers. And so the FSCA will have authority, all the same powers they do in respect of a fund or an administrator. They will have the same authority over the employer with regard to the employer's duties in the Pension Funds Act. I mean, obviously, they don't have complete control over the employer, but any of the employer's obligations in the Pension Funds Act, like paying the contributions in time, the FSCA will be able to use their resources to go after the employer, which include issuing an administrative penalty against the employer. And I would think that would be, or issuing an undertaking, and again, that's a reputational issue. But I think the administrative penalty, on top of the late payment of the contributions plus the penalty interest, plus then an admin fine would be quite off-putting for employers. But that is still to come.
Thanks, Fiona. Just a question from myself. So how would the standard applies if a fund submits a rule amendment and the new contribution rates are a bit lower in terms of the rule amendment? They've submitted it to the FSCA, but it hasn't been approved, and now they start paying at the reduced fee.
Oh, that's such a sneaky question. So I'm going to give you the legal answer, and the legal answer is you have to change those rules prospectively. So there's two reasons why you need to do those prospectively. First of all is that section 13A5 says you may not reduce contribution rates retrospectively. I mean, it actually says quite clearly that you may not do that. And the second is that trustees, funds, administrators may only act in terms of registered rules. We are not allowed to act in terms of unregistered rules. So it's section 12 and section 13.
Thank you. I think there's a question in the audience.
I think my question would be, what is the time frame for companies liquidating to notify the fund and also to pay over contributions?
So by when must contributions be paid?
By when should they notify the fund that the company will be liquidating, and then also by when should the contributions be in?
Okay, so as soon as possible, in the case of an employer that is liquidating, because there are rules of the fund, and the rules will say, although the employer is liquidating, their participation in the fund also needs to be put into liquidation, which is a separate process in terms of the fund rules. And you definitely want their participation in the fund to terminate before or when they go into liquidation. Because if you terminate their participation after they go into liquidation, we're going to have a real problem to get in arrears contributions. So I would say as soon as possible, so that we can time their termination of participation in the fund before they go into liquidation. And so we can kind of start at least wrapping it up from that perspective. With regard to when contributions are due, so the monthly ongoing contributions are due by the 7th of the month following the month to which they relate. So contributions for the 31st that are due in March must be paid by the 7th of April, as an example. And then in liquidation, they would be payable right up to when the fund liquidates, that date of termination. So it could, it doesn't often happen, but I suppose it could terminate mid-month. Then we need a pro rata. Typically they terminate their participation at a month end. So if they terminated, let's say 1 May, we'd still need the April contributions in.